Welcome back. Good to have you again. So we have what I would consider the most fundamental topic in business law, and that is contract. Because you can't talk about business without talking about contracts. So what is a contract? What is a valid contract? There's so many agreements we enter into every other business day that constitutes contracts or constitutes agreements, but are they valid contracts? Are they valid contracts? Or are they void contracts? Are they voidable? What can we do to make sure that we have correct and valid contracts? So let's look at it. Talking about contract, a valid contract is a legally binding agreement that recognizes and regulates the rights and the duties of the parties to the agreement. A contract becomes legally enforceable when it meets the requirements and the approval of the law. Basically, a contract is a promise for a promise or an act. A contract, express or implied, has four major elements. There are four major elements that constitute a contract, and they include, but not limited to, the following that you could have heard of in the time past. What are these elements? We're talking about the capacity to enter into a relationship. We're talking about furnishing consideration, talking about legality of that agreement. We're talking about mutual understanding of what has been agreed. So basically, what do all these things mean? Talking about capacity, we're talking about your ability to enter into that contract. Do you have the contractual ability? There are people without contractual abilities. For instance, a minor. A child cannot enter into contract apart from contract for his or her necessities. Another instance is someone of an unsound mind. So the law has different regulations or different provisions depending on the jurisdiction of who is qualified or not qualified to enter into a contract. Any contract sought and gotten by any of these unqualified people can sometimes be construed under the law as having been gotten via undue influence. However, we're talking about another factor that is very important, that is mutual agreement. There must be an agreement, a meeting of the mind, what the lawyers in our Latin magazine will call consensus addendum. Consensus addendum. That means the meeting of the mind. Both parties have to agree on what they are doing. They have to agree on what the promise is, and they have to agree on what the consideration is. And that brings us back to the consideration. There must be furnished consideration. There must be an action or inaction, taken or not taken, as a result of the contract. So it must be something of value exchanged. Legality means that you can only contract to do what is legally acceptable. You cannot contract to do a trade, go into slave trade, prostitution, drug deals, and all that. These are invalid ab initio because they are illegal. So a contract becomes invalid and unenforceable if it is missing one of the above requirements. Yes. Now, let's talk about consideration, for instance. It is the bedrock of a contract. It is the this for that concept. It can be an action or refraining from taking action. Now, you see, consideration need not be sufficient, but it needs to be adequate enough to constitute a contract. However, illusory promises, gifts, past considerations already obliged to do, or moral obligations cannot be considered as valid forms of consideration. Now, let's look at something else of importance, and that is what I will consider as the boilerplates. The boilerplates of contracts. What are these boilerplates? Boilerplates clauses happen to be they're like standard and miscellaneous or general clauses that are seen towards the end of most legal agreements. This provision addresses a range of things such as what happens if a document is declared unenforceable by the court, or how disputes will be resolved, or which laws govern the contract, and more. See, these general clauses may be considered secondary, to the significant part of the document because they use standardized language and are buried near the end of the agreement. But do not be deceived. They should not be mistaken as unimportant, and parties should pay as much attention to them as they do to main clauses such as payment. So let's look at some of these boilerplate clauses. For instance, costs. When it comes to litigation, who bears the cost? Most parties agree that the losing party will bear the cost. In other words, if we both are saying that we are right, and nobody wants to agree that the other is right and they are wrong, and we go to court, whoever that the court finds to be the person at fault should bear the costs of going for litigation or going for any other dispute resolution platform. That's a way of saying that you should be able to examine your stand before you activate the legal process. ADR, that's alternative dispute resolution. How do you intend to resolve dispute? You want to use mediation? You want to use arbitration? So if you say you want to preserve the relationship, you don't want to go through litigation, how else do you want to resolve conflicts should they arise? Governing law has to do what state's law will apply in a dispute. Jurisdiction has to do with what lawsuits, where a lawsuit must be filed. What court should have jurisdiction over these cases. Sometimes these are not things you determine by yourselves, by your contract, but the wordings and the object of the contract determines where these issues can be brought or what courts can handle these issues. Waivers, we have other things like severability, we have integration, we have notices, what constitutes proper notices and when is it deemed to have been received. We have relationships. The relationship has to be defined. That you are my agent does not mean you are my employee. That you are my consultant does not mean that we are in partnership. So these things have to be defined in the contracts. Then assignability and delegation, what can be delegated, what cannot be delegated. Do you understand? I think there's a legal maxim, I can't remember how exactly it's said. I think it's delegatus non potet delegare. It means someone that does not have the right to delegate cannot delegate, or someone that has been delegated to has no powers to delegate. So what can be delegated and what cannot be delegated? You cannot delegate powers that you do not even have ab initio. So talking about warranties, parties warranting to do this or not to do that. Talking about indemnity, parties warranting to indemnify the other party for any loss arising by their actions or inactions or by their agents or by any other reason. Talking about counterparts of the agreement. So lots of these are things you find under the boilerplates. So let's look at the remedies. Should there be a breach of contract? Should you agree with Mr. A or B to do an action and they fail to do it? What happens next? What brings us to the remedies. What are the remedies? So remedies could come from different forms when there is a breach. These include compensatory remedies, consequential remedies, and punitive remedies. There are other kinds of remedies. Talking about compensatory remedies, they exist to compensate you for the breach and put you where you would have been if no breach had occurred. Consequential remedies, when court decides to go to adopt them, they have to do with making sure that breaching side pay for all the problems that arose from the breach and is usually limited. Punitive remedies, not very popular in contract law but popular in torts. It's only available if the breaching party was willful and reckless. So if a person failed to take due diligence in his or her actions, and as a result there is breach of contract, then punitive measures may be put in place by the courts to discourage other people from making such mistakes in the future. So again, courts can decide to use a combination of both or two or three or more remedies depending on what comes to their discretion and what is prayed to them, as the court cannot give you what you are not asking for. So you have to know what is available, what can be given, discuss with your attorney and know what can be given so you know what you pray the courts for. So let's go to frequently asked questions when it comes to contracts. Some may ask, are oral contracts valid? Yes. Express contracts are stated in words, whether oral or written. Problem usually is evidence. It ends up being he said, I said, all those kind of reported speech, your word against theirs. But some deals must be evidenced in writing. Paying another's debt, for instance, sale of land, trust in property, performance that takes over a year plus, a sale of goods $400 and above in some jurisdictions. These things have to be reduced in writing to avoid stories that touch. One may ask, can an email be a contract? Yes. A contract is a promise for a promise or an act. So if a series of written documents evidences all the requirements of a contract, so be it. It's a contract. This raises the points of implied contracts, implied by conduct, actions versus words, implied by law, courts. When things like this occur, the courts will create a contract to avoid one side benefiting at the expense of the other party. Question is silence acceptance? Some may be asking, can silence be considered acceptance? No. The offeror cannot impose a duty to the offeree to do something as there is no previous obligation. But there are a few exceptions which may arise if the offeree takes action based on the offer or in mutual agreement. Both parties agree that silence is acceptance, or prior dealings evidence silence was construed as acceptance. The courts, based on the preponderance of evidence before it, might construe silence to be acceptance. Another question is, what is the statute of limitation for a contract claim? That is, if there is a breach, how many years can the injured party bring a suit? What's the time period, what time frame within which the injured party can bring a suit? The prescribed period for contract under Section 8 Sub 1A and the 12 Sub 1A of the limitation laws of Lagos State is 6 years for simple contracts and 12 years for contracts under sale, that is made by way of deed. Different jurisdictions have different limitation period. Typically, most construction contracts are made by way of deed. So a claim for breach of contract must be commenced within 12 years from the date the event giving rise to the breach occurred. In the event that the construction contract is not made by way of a deed, a simple contract, the limitation period will be 6 years. Question is silence acceptance? We've said that before. Now, questions are non-compete and non-disclosure agreements. Are they enforceable? You may be asking. Non-compete, non-disclosure, are these things enforceable? Yes, non-competition clauses can be enforced in court. It is true that employers face an uphill battle in getting a judge to agree to enforce a non-compete, but it can and does happen. So if you're wondering whether your non-compete will stick, ask an employment lawyer. Enforceability of a non-compete depends on the specifics of the wordings of the clause itself and the overall employment contract. Some key considerations are whether the clause is clearly worded and whether it is limited in time, geography, and scope of what is covered. Typically, the court may weigh the inherent risk to the company vis-a-vis the employee's ability to make a living and public good. NDAs are enforceable if beyond executed agreement you can show existence of trade secrets and confidential information being shared, that it was acquired improperly or as a result of a relationship and there was actual threatened and unauthorized use of the secret or confidential information. So you have to be very careful. Your attorneys can draft whatever they want to draft for you, but you have to consider the legality and your ability to supervise and enforce your own agreement. Ambiguity is construed against the drafter, so evaluate your parameters for deciding who should draft a contract agreement for you. Always advise your attorney to use non-ambiguous words, which they might have adopted to impress you. Insist that your contract agreement has a definition section where vague and recurring terms are defined clearly within the context of the agreement. In addition, develop an existing strategy should you need to repudiate a contract. If you are the non-breaching party, try communicating first. This may be relied on as evidence against the faulting party. Explore ADR options before a final recourse to lawsuits. So that brings us to an end of contract in a nutshell. This is not exhaustive in any way. There is more to contract than what I've just said. However, should you have questions or other concerns about contracts, you know what to do. Send me an email and I'll be glad to attempt your questions. But till then, I look forward to seeing you on the next slide, where we'll be handling risks and due diligence.